Next will be Kendra Johnson, who's an attorney here in the area, and she's going to come up and discuss some of the legal aspects of as we get a little older, and I'm being careful with that terminology, but I want to make sure that she has her ability to discuss some of the important aspects that you need to know.
Thank you, Dr. Newby. Good afternoon, everyone. I hope you guys are enjoying this afternoon and we're not boring you or making you fall asleep out there. So I'm going to try to be engaging with my presentation today. I just wanted to talk to you guys a little bit about some of the options. And the options that I have available for you guys are wills, powers of attorneys, and I'm going to touch briefly on advanced medical directives, but I'm going to let Ms. Butler finish talking to you guys about those. So one of the main things that we battle against in life, and if we're just honest, everybody loves a good story, right? Every story has a hero and a villain. And sometimes in life, the subtle villain that we run up against is time. Nobody knows how much time they have to live on this earth, and at any moment your time can be shortened or your life can change. What I want to talk to you guys about are the legal options of planning for any type of change that can happen either by death or by incapacity. So the first area I'm going to talk to you guys today about is wills, and then the second one I'm going to talk to you guys about is power of attorneys, and the third one I'm going to talk to you about is an advanced medical directive and what each of those documents are. How many of you guys already have a will drafted? By show of hands. Okay. So a will sets up the way that you want your property to be distributed after your death. If you don't have a will, I want to talk a little bit about what that looks like, just so you understand the importance of having a will document drafted, and also that your will is tailored to have your property distributed exactly how you want. Now, if you don't have a will in the state of Virginia, then there's something called intestate succession. And if you don't have a will, there are people automatically in place who are lined up to get your property, and people who you may not want to get the property the way it is. For example, if you're married and it's not your first marriage, say it's your second marriage, and you have children from your first marriage, you may want your spouse to get everything after you pass. But if you don't have a will in place, the way the Virginia law is set up, you would have your spouse get 1/3 of your property while your surviving children would get the other 2/3. So that's why it's very important, if you do have a spouse and you want your spouse to have everything and it's your second marriage, that you have a will in place specifying that that's the person you want to have that property. When we discuss wills, there are some terminology that I want you guys to be familiar with. So if you speak to an attorney about it, or if you're talking to someone about it, I want you to know this terminology. The first bit of terminology I'm going to explain to you guys is a testator. A testator or a testatrix is the person who is writing the will and on whose behalf the will is being written. And then the executor, executrix, is the person who is going to execute the will on your behalf. So this is going to be someone who you trust to be able to distribute your property after you pass. And you want to make sure when you're picking this person, it's someone who knows how to locate the property, that you speak with them beforehand, so they know once you pass how to get the property to the beneficiary, which is the person who you want the property to go to. Another aspect with wills is sometimes we get in these situations after we pass, and I'm sure some of you have had these things happen, where everything's fine with your siblings, before the parents pass. But then suddenly when the parent passes, there's this huge fight about the property. Well, if you tailor your language in a will, you can actually tailor your language such that if anyone starts to fight like that, they'll get disinherited. You can do things like that with your will just to prevent people from making a big fuss about things after you pass. So those are some options available to you with your will. The next document I want to talk to you just briefly about is something called a power of attorney. Now, power of attorney documents is a document that you you can either use it for your incapacity, or you could just have it effective until you're incapacitated. There are lots of reasons why a power of attorney comes into play. A simple situation, and I think we often think of it when we're getting on in age, but think of it in another way. Say you're driving one day and somebody rams into the side of your car and you lose consciousness, and you don't regain consciousness for a few days. Who's going to manage your affairs? Who's going to make sure that things are taken care of on your behalf? That's a simple moment where incapacity can happen that we don't often think about, which is why it's so important to have a document in place just in case something like that happens. Now, power of attorney can be general, meaning it's very broad and it can grant lots of powers. going to court on your behalf. The person can sell property on your behalf. They can do a lot of things. Or it can be limited, and the limit can be in scope and in duration. In scope meaning in what they can do, in duration meaning in how long it takes effect. For example, one that people don't often think about for a power of attorney is if you're a parent who's leaving the country and your minor child needs someone to take care of them. You could do a power of attorney for that type of instance as well. And then there's also the power of attorney that is only takes effect upon your incapacity. So you can tailor this document in many different ways, but it's very important to have, because if you have that situation occur where you are unable to make decisions on your behalf and something happens, then you need someone who you trust, and that person's called an agent, to be able to make those decisions for you. And the third area that I'm going to discuss just briefly is an advanced medical directive. Now, you can have a medical power of attorney, which allows someone to act in regard to medical decisions if you're incapacitated. And then there's an advanced medical directive, and I think Shamika is going to get a little bit more into the differences between the two of those, so I'm not going to touch on it too much. But I do want to talk about what the process looks like if you don't have these documents in place. Now, if you don't have a power of attorney in place, what's going to happen is your children are going to have to try to petition the court to get guardianship over you. And it doesn't even have to be your children. If you become incapacitated without one of these documents in place, it says under Virginia law that any person can petition the court to be your guardian. And if you don't want that type of fight happening between your family members, it's probably better just go ahead and appoint who you would like to be an agent to act on your behalf in advance. I think the main thing that underlies all of these documents is planning to prevent fights. You want to make sure that when something happens, you know exactly who will be taking care of you and how they will be taking care of you. So I'll let Shamika get a little bit more into the advanced medical directives and petitions. I can discuss a little bit more about petitions for guardianship in the panel if you guys want to ask questions about that and what that process looks like. Or if you have someone who's struggling with their capacity right now, the type of process that you would have to go through to try to petition the court essentially to get to be able to be their guardian, to help them make those type of decisions. So if you guys have any questions, I can answer those questions for you now. If you have any questions about the legal aspects of it, or I can't answer specific like case-by-case scenarios, but general questions I can answer.
And I think it's extremely important, just as a physician, I can tell you just personal, firsthand, dealing with people that are in that situation where the family member may have made a comment about what their wants and desires are, but they never had it physically in writing. And then you get family members that sometimes don't want to necessarily agree, and I'm being very diplomatic when I say it this way, but it can be interesting dealing with family dynamics. And I've seen it break up families, tear them apart, because unfortunately sometimes people cannot separate their emotional side from the side of doing what's in the best interest of their loved one. And I know it's difficult. I know firsthand it is. So it's important that that happens. So I just wanted to throw that in there to say it's nothing worse than seeing a family tear itself apart because that document was not in place. But questions? I think I saw a hand over here.
Can you explain last will and testament?
Yes. So the last will and testament is the document that governs your property, your assets. There are certain things that don't fit within that, like for example, if you have a life insurance policy, there's already a beneficiary set up under that document. Same thing with your retirement plan. There's like a beneficiary in that plan. But the last will and testament governs any property that you have. So if you own a home, if you own a car, if there are items within your home that you want to go to specific individuals, those are the type of items that would be governed by a last will and testament. And that document, it would be drafted by the individual who owns the property, and you would just state in your document, and you would list your name, being of sound mind, hereby I leave whatever properties to, and you would name the individuals. And you'd also, within that document, name someone who would be responsible for giving the items that you're leaving to the other person.
Any other questions?
Can I just ask, does that also cover something like 401K or something like that? That's not physical property, but that's...
No, a 401k with any kind of contractual document, something like a 401k, you have to look at how it passes under the document. So if it's like a 401k, if it's a particular plan, that plan typically says how a beneficiary is set up, and your will won't touch that. So you could say, I want the stuff in my 401k or my life insurance plan to go to someone, but unless it's in that plan, it won't work. So you need to make sure that those documents stay separate. The will talks about your specific property, like your bank accounts, as long as it's not like a payable on death account. If it's just that asset, you can leave the funds within that bank account to a person.
Okay. And she will be staying for a little bit after this, so if you have any questions that we're not able to do, because I only have time for one more. And first takers on one more question. Okay.
Do these documents have to be notarized?
Yes. So the notary is best to have because a notary is someone who will swear that you are the person who signed the document. They'll have a notary will have like a sworn statement stating that you were of capacity. Technically, you can get away with a will without it, but then your will can get challenged. The purpose of making sure that you get a will notarized and with the proper witnesses, which is why I usually recommend people at least get an attorney to look over it, is so that it doesn't get challenged and it can do what you want it to do after your death. Because once you're gone, you can't come back and change the language in that. You want to make sure that it's ready to go and that everything that you desired for your estate happens when you pass.
All right, well, thank you very much. Again, it's Ms. Kendra Johnson, and she will be available for a few minutes after we're all done.